Running a business comes with constant learning, and that's where the Business Blend comes in. Every month we bring local entrepreneurs together for a quick, practical talk on a business topic that matters, followed by a time to connect and share ideas. It's a simple way to stay sharp and build a stronger community.
Yeah, it's great to be here. I'm happy to talk to you guys about estate planning. I'll give you a quick idea of how the structure is going to go. I'm going to walk through this presentation. We're going to talk about estate planning, different types of plans you'll see, the different types of documents, and how your business can fit into your estate plan. And I'm going to run through that, and I'm going to leave a good bit of time for questions. So it's about me. I'm not terribly interesting. I've been an attorney for a while. I primarily do estate planning. I do probate, trust administration as well. I do a good bit of small business law, and I do a little bit of real estate as well. I was a financial advisor also for a few years before I practiced as an attorney. I've got 4 kids. We live over in Moscow, and I'm a actually extremely avid outdoorsman. Enough about me. All right, let's talk about what estate planning is. So I've got a definition up there. Upon death or incapacity, estate planning directs the disposition of your assets, provides care for minor children, and selects decision makers for you or your estate. I also like using this definition as a little bit more succinct, which is estate planning is your say in what happens to you, your family, or your assets upon death or incapacity. Now, as you see in that definition, there's the or incapacity side of it. Estate planning isn't just about what happens when you pass away. It also applies to your life as you are alive, if I could be so eloquent. You need to have people that are able to make decisions for you, for your children, or for your assets if you are unable to. So with that definition in mind, I'm going to talk about the 3 different types of plans. There's really 3 different types of estate plans. We've got this Venn diagram up there. So I've got on the left side of the screen, you've the different types of plans. You have no will or trust, you've got a will-based plan, and you have a trust-based plan. On that diagram, you see the circle that says individual control and the circle that says government control. I'll talk about what that means. Individual control, fairly self-explanatory. That is your say in what happens to you, your family, or your assets upon death or incapacity. That's the amount of control that you exert on your plan. Government control, what I mean by that is government control is what a judge or state law is going to say about your plan. That's how much oversight those institutions have on your plan. Now, if you do not have a will or a trust, so down there on the bottom, your estate is what's called intestate. So state law governs how your assets are distributed. In Washington or Idaho, in both states, there's a statute that lists out the rules of intestate succession. Those govern how your assets are distributed. It's based on a formula that takes into account closeness of relation and number of relations. So, spouse, children, siblings, parents, grandparents, cousins, nephews, whatever. But there's a scheme of distribution that doesn't change. You don't have any control over that. So your estate's intestate, it goes into what's called intestate probate. I'm going to talk about probate specifically here in a few minutes, but this is what's called intestate probate. A judge is going to appoint the administrator for your estate. You're not going to pick who's going to handle your estate. The judge is going to, or the state law is going to decide how your assets are divided. Also, as you see, that court appoints guardian of minor children. A judge is also going to appoint a guardian of your minor children. That is you have to go, when you don't have a guardian designated in your will, a guardianship proceeding has to be opened in the court. You have to get several attorneys involved. You have to get a social worker involved. It takes a while, and you don't know who's going to raise their hand to take care of your kids. I run into issues a lot when you have a very well-meaning family member who raises their hands to take care of the kids, but they happen to be the family member if you could pick, wouldn't pick. So that's a concern that unfortunately many families have. So With this, again, a judge is ultimately the one who decides who takes care of your kids. And then I have done their high court costs. All of this is expensive. Guardianships are expensive, and intestate probate's expensive. So, not to, when I talk with clients, I don't want to belabor how scary this is, but this is not an area you really want to be in because you have given up all your control to outside entities. Moving up to a will-based plan. So as you can see there, you've got the wills kind of in the middle. So there's still going to be court oversight, but you still are going to exert more control on your plan. With a will, you now are in the driver's seat of deciding who your executor, or in Idaho and Washington, it's called personal representative, is going to be. Who's the person who's going to administer your estate? You appoint the person you want to be the guardian of any minor children that you might have. And you can also say who gets what. You're not bound by the rules of intestate succession. You can give different amounts to different people. You can give specific items to specific people. You now are able to control that aspect of your plan. You still do have to go through probate. So there still is going to be court oversight. You're still going to have to go through the court system. Probate is a process in which the personal representative, gathers assets, notifies creditors, pays debts, deals with taxes, and ultimately distributes assets according to the terms of the will. In my experience, you're looking at it's a between 9 and 12 month process is how long it takes to do probate. And as with anything, the longer it's out there, the more likely a problem is going to crop up. So as you see there, it says lower legal costs, and this is going to be a theme as you go up the list. It seems a little counterintuitive that, okay, if I don't have anything, obviously that's the cheapest option. It's actually the most expensive because of all the things you have to deal with. With the will, it's going to be still, you got to make a will, you still have to go through probate, but since you have more control over your estate, there are less issues that have to be dealt with, which ultimately actually lowers your costs. So, moving to the final one, a trust. Trusts give you the most control. Now, a trust does everything a will does. It appoints a decision maker for your assets. It appoints guardians. You say who's going to get what, but a trust does a couple other things. One is it allows you to skip the entire probate process. You're able to walk around that. A properly set up and properly funded trust will allow you to avoid probate. I'll talk about funding in a little bit, but if you set your trust up right, you're not going to go through probate. So you're able to save that time and money and hassle. This is particularly beneficial to married couples because when the first spouse passes away, if you have real property or if you have really any assets at all, you're going to have to go through probate, which it's not really ideal when you're mourning the loss of your spouse to have to then, go down to the court and deal with all of the just headache of dealing with probate. A trust allows you to, mourn and things will just keep moving along. Nothing really is going to change. So, no probate. That's the first difference. The second difference is you now are able to not only say who gets what, but you can say when they get it and how they get it. So you are able to control the distribution after you pass away. With a will, when the will goes through probate, they immediately make out the distributions and the person receives it outright, which might be great. However, in a lot of situations, people want to have the ability to control that distribution depending on the situation. For instance, you have small children. My oldest is 15, my youngest is 5, so I've still got another 13 years before all my kids are grown. A 18-year-old, generally speaking, in my experience, is not very good at handling a significant amount of money. Now, you can be a younger person and say, oh, well, I got my house, I still have a lot of mortgage to pay on it, I've got a small retirement account, I don't really have that much, but they actually also have, $2 million in term life insurance. Well, that's an asset of your estate. If you were to die while your child was young, that term, there's going to be $2 million going to your kids. I've got 4 kids, so that's $500K per. I don't know about, you all, but when I was 18, if I got $500,000, I wouldn't have it right now. I would have an old pickup truck and an old bass boat, but I wouldn't have much. I wouldn't have any of that money. So this is a way that you can help your children steward the legacy that you're leaving them in the form of their inheritance. So that's one benefit to controlling that. The other is, I'll say, is more behavioral. There is, in my trust, I have a list of things where the trustee is told not to make distributions. Substance abuse, gambling addiction, pending lawsuit, pending bankruptcy, pending divorce, being bad at handling money. Those are all situations where if someone receives a good bit of money, the research and the stats are pretty clear that they're going to lose it. You have substance abuse issues, gambling issues. We all know how that goes. Bankruptcy. Well, that's going to be subject to the bankruptcy court. Any pending lawsuit. Well, maybe there's a judgment gets handed down against the child that's inheriting or whoever's inheriting, and that gets subject to a court judgment. Anyway, as you can see, there's a lot of situations where if you give them money, if you give your child money in that situation, you're leaving, that money's in danger of getting spent. So the trustee is allowed to put the kibosh on that distribution. So I'm hoping that you guys are starting to get an idea the amount of control that you can exert over your plan in that situation. I'll talk a little bit about tax benefits, particularly because we're in Washington State right now. With trusts, there are two different types of trusts. You have revocable trust and irrevocable trust. A revocable trust is one you can amend. So you can change the terms of it as you go along. They're extremely useful, and they're extremely useful for most people, if not everybody. But they don't give you really any tax benefits. There are no tax drawbacks to revocable trust, but there aren't really any tax benefits to it. Irrevocable trusts are where you can get tax benefits. Now, Washington has a state level estate tax. Idaho does not, but Washington does, and obviously there's the federal one, which, hopefully all of you guys have estate tax problems on the federal level, because that means you're worth over $25 million. Most of us are not, but in Washington, the amount they just recently bumped it up from $2.193 million to $3 million. That is the exemption amount, which means that anything below $3 million, anything above $3 million, is subject to estate tax. That is where irrevocable trusts come in. At that point, you can use those to plan for estate taxes, try and minimize your estate tax exposure. I'm not going to get in the weeds in it right now. If people have questions about it later, I'm happy to discuss them. But there are ways you can minimize your estate tax liability with a trust. And then finally, it says low cost up there. If you look at estate planning as a whole and you include probate and everything, if you look at how much your estate planning costs over your life, a trust is actually the cheapest option. You pay up front, but you pay way less on the back end. But as you can see, that's kind of a theme here. The more control you're able to exert on your plan, actually the cheaper things get. So those are the different types of plans and kind of how they work. I'm going to move on and discuss the estate planning documents themselves that you'll see in a plan. But I mentioned funding. I'm going to come back to funding because when we talk about estate planning as it applies specifically to a business, we're going to talk about funding the trust because that's how you put everything into the trust. So moving on to the documents. So that's a list of documents. You get wills, trusts, powers of attorney for healthcare and finance, a living will, which is a medical directive, which is an advanced directive, HIPAA release, and then there's other documents. So a will and trust, we've kind of already been discussing those. Most people, you understand. You're appointing guardians, you're saying who's going to get what. And in the trust, how and when they get it. Power of attorney. You have one for healthcare, you have one for finances. A power of attorney is your grant of decision-making authority to someone else on your behalf. And that takes place during your lifetime. When someone passes away, a power of attorney is no longer, it's just terminated because it only applies during your life. But it's there, so if you are unable to make decisions or handle your situation because of some sort of incapacity, or maybe you just aren't around. You're in Europe and you need someone to sign a document for you. That's what those power of attorneys do. So you have one for healthcare, that's healthcare decisions, one for finances. That kind of covers everything that you're going to have in your life. A living will or a medical directive, that is your instructions on when to remove life support. You are stating at what point you want life support to be removed. In Idaho particularly, I know Washington's a little different, but generally speaking, the only people that can say when life support can be removed are you and a judge. So that's your instructions. Everyone remembers, well, maybe not. Some of us older people remember the Terry Schiavo case. That was over a healthcare directive. So she didn't have one. So that ended up going up to the Supreme Court, and they got George Bush involved in all of that. So probably not, it's not gonna be that extreme ever again, probably, but you do have to go to a judge generally if you don't have a living will. HIPAA release, that works with your healthcare power of attorney. That's a release of healthcare information to your healthcare agent that you've appointed in your healthcare power of attorney. Those are really helpful to have. We really think you should have one if you have a healthcare power of attorney. I ran into a lot of issues early in my career where I have a client have a healthcare power of attorney for their parent. They didn't have a HIPAA release, so then there was kind of like, you can only tell them so much, and anyway. So then we've got other documents. So this is where I'm gonna talk a little bit about businesses. So the other documents, generally speaking, are what I'm gonna call funding documents. So let's talk about funding your trust. You have a trust set up, you need to get your assets in there. So you do that by funding the trust. Real estate goes via quitclaim deed. Personal property goes by what's called an assignment of personal property. And then business assets, a business interest, go via just whatever transfer document, transfer shares, assignment of interest of an LLC, interest, things like that. You can put your business into a trust. So your trust can own the business. You still own it. It's kind of like owning a piece of property through your LLC. You got a rental property, it's in your LLC. Your LLC is the owner of it, but you still are the owner of it because you're the one that owns the LLC. So it's still your asset. Same thing in the trust. You put your business into the trust. So you've got an LLC. So you've got a single member LLC, and you don't want, it's an asset. It's what's called a probate asset, and it will be subject to probate. Well, you don't want to deal with that. So you put it into the trust. You sign an assignment of interest of your interest in the LLC to your trust. The trust is now the sole member of your LLC. And when the annual report comes due, you go on, and instead of the Ellis Eifert LLC, it's now Ellis Eifert being the owner of the LLC. It's now Ellis Eifert's Revocable Living Trust is the owner of the LLC. That's fine. That's legal. You can do that. And it allows you to transfer your business without having to go through a probate court, which makes things a lot easier. That is a very easy way to deal with the problem of probate, because a lot of times people just kind of forget their business is an asset that could cause probate. They're like, well, my house, I've got all these assets, I've got this big investment account. Those are all things that need to get in. But then I've got my window washing LLC over here. I don't really know what to do with that, so I'm just going to assume it's not an asset. It is an asset. It's a probate asset. You have probate assets and non-probate assets. Non-probate assets are ones that are not subject to probate. That means the asset passes according to operation of law. So short, kind of rule of thumb, if you have an account that has a beneficiary designation, whether it's a retirement account, just a joint account, money market, life insurance policy, those pass outside of probate. You still want to point them at your trust, and I'll discuss that a little bit more when I talk more about funding. Everything else is a probate asset, and that includes your business, which is an asset. So that is a way to get it in there. Other assets, like I said, real estate, it's going to be a deed, assignment of personal property. If you've got vehicles, do a transfer of title at the DMV into your trust. Financial assets, for like an investment account, saving account, you make the trust the owner of the account. So you go into your bank and you say, hey, I need to get this investment account, this individual brokerage account into my trust. So again, instead of Ellis Eifert, the individual owning that investment account, it is now the Ellis Eifert Revocable Living Trust that owns that investment account. Life insurance policies, my recommendation, have the trust be the beneficiary. The reason for that is, let's say your spouse is the beneficiary on that, not going to hit probate, but he or she might end up getting a $1 million payout, and unless they take the affirmative action to put that in the trust, they leave it outside, your estate still is subject to probate. So it's a way to make things easier and more smooth. Retirement accounts, the Secure Act came down a while ago and changed a lot of the rules around distributions of IRAs and qualified retirement accounts. We used to have a thing called see-through or stretch provisions that we would put into the trust that allowed the retirement assets to be stretched out and take advantage of the income tax benefits of that. You're not allowed to do that anymore because there's a requirement that everything be taken out in 10 years with a couple of exceptions, one of which is for your spouse. So my recommendation for retirement accounts, generally speaking, I would say, your situation might be different. Generally speaking, my advice is, make sure that your spouse is the primary beneficiary. And then if you're worried about your kids, maybe there being an issue, you can make the trust the alternate beneficiary. But your spouse will be able to take advantage of the income tax benefits of stretching out the distribution, or having the option of stretching out the distributions from the IRA. Otherwise, if it's a joint, if it's a bank account that has a beneficiary designee, generally you can go ahead and just have the trust be the beneficiary of those. So those are the documents, and that's a little bit about funding, in particular how your business gets funded in there. The process of doing this, I'll go real quick. Contact your attorney. I know, of course, I'm going to say that, but I'm going to call an accountant when I need to do my taxes. That's what I'm going to do. So, talk to your attorney. Take inventory of assets. Taking inventory of assets is actually very helpful for a lot of people because you just forget stuff. You forget about that 401k from that job you worked 10 years ago that now has $20,000 in it because you funded it. You funded it 1 year and then you left and it just sat there and it just grew, and then all of a sudden you're like, oh, whoa, I forgot I had this. So it allows you the time to go over and take inventory, categorize, organize your assets. So establish your goals. Think about what you want your estate plan to accomplish. What is in your situation that needs to be addressed? Children, aging parents, again, like I mentioned, unfortunately, maybe a child that's got some sort of issue, things like that. Think about what your goals are. What do you want to happen? Or do you have charitable intent? Do you want to give money to charity? Are you trying to minimize your tax burden? Because, like I said, we're in Washington State, and you are subject to the state level estate tax. So think about what you want to accomplish with your estate plan. Then select your plan. Talk with your attorney, and then select which plan makes the most sense for you. Do you just need a will? Do you need a revocable trust? Do you need a revocable and irrevocable trust? Do you need some sort of Medicaid? What do you need to do? Figure that out and select the plan that you need. Then execute the plan. Make sure you execute the plan. I know, I'm gonna tell you, it is interesting to me. It's funny, unfortunately, how many people do everything, get to that point, their attorney drafts the documents, they get it, and then they just don't sign it. It's not worth the paper it's printed on unless you sign it. You can go to a judge and say, here, and the judge is like, yeah, you didn't sign it, so sorry. So make sure you execute it. Then review it annually. It's a good idea to look at it every year, and I'd say every 3 years it's good to just sit down with your attorney again and just go over what your life looks like at that point. Your life's going to change. Your estate plan is going to change with you. Obviously, when you do it up front, you're going to spend a lot of time. It's like building a house. Most of the work's going to happen when you build a house, but you're going to probably update, repair, etc. as you go along. Same thing with your estate plan. So review it annually. With that, questions, particularly if people have questions about what to do with their business. So I kind of touched on that, but I wanted to leave some time for people to, if you have them, ask me questions about that or anything to do with estate planning. Yes?
In a multi-member LLC, how does an irrevocable trust work where your shares like increase or get diluted? Like how does that interact?
Yeah. Well, if it's in a irrevocable trust, you don't own it anymore. It's out of your estate. For a revocable trust, and it would work the same way either way. For a revocable trust, it will work the same as it would otherwise. So now your trust is simply the member that you were. So if your shares get diluted, well, they're going to get diluted whether it's you or whether it's your trust. Ultimately, it's still yours. And everyone knows that, the IRS knows that. It's just this is a vehicle to avoid probate and to manage your distributions of your estate. So.
Okay, so irrevocable trust exists, but like where? Does it get its own EIN number or like?
A revocable trust, generally people just use their social security number. Like when I draft my trust, I leave it an option that either spouse, if it's a married couple, can use either one of their social security numbers as a tax ID number, or obviously if it's just individual, be theirs. And you also can get an EIN if you'd like. You can apply for an EIN. For an irrevocable trust, you're going to get an EIN. You're not using anyone's social security number. You're going to just get an EIN.
Is there ever a situation where a will is more beneficial than a trust? Because it seems kind of like a no-brainer.
Yeah. I would say there's a very specific situation where I think they're better. And that is if you are somebody, generally it's going to be an older person or older couple. They have basically spent down pretty much all their assets except their retirement account, and they live in an apartment. So let's say their asset is their 401k and then, or their IRA, and then they get Social Security, et cetera. That's their asset. That's how they live. And they live in an apartment, they drive an old Subaru, and they've got, they don't have a ton of personal property. In that situation, I'd say a will makes sense. The reason you want to have it is just in case something happens. Who knows? That they might win Powerball. I don't know. So you have to have something there to kind of help govern that. But that situation where it's very, very low probate assets. I mean, they might have a 401k that's worth $1 million. That's still not subject to probate. But it's just they've gotten rid of all other probate assets that they have. In that situation, I would say a will would, because there's really no need for a trust at that point. So.
I guess I would ask the question, are there any other things that you see kind of in your position, which are kind of these bugaboos for you? Like people generally have a bit of a mistake here or there, or is there something that you look out for to make sure that we don't do?
Yeah. Not executing and not funding your trust. So not executing your documents, signing your documents, not getting around to, you spend all this time and money and effort setting up this plan, and then you don't have any assets in your trust, for instance. So it's just like the last little bit that didn't get done, but it's important because if you don't do it, then if you don't sign the document, then it doesn't work at all. If you don't put the assets in the document, you might as well not have a trust at that point. So just making sure that people have actually made sure everything goes in there, and make sure everything goes in because you miss one thing that has enough value that'll, even if you put everything else in there. So you kind of have to make sure you do get everything in there. Yeah. In regards to the documents, that's what I would say. Yeah.
And this is once again my own confusion. So then, like, if somebody does have a will, how does the courts or judges know the will exists if the person has passed away?
Yep. Generally, the reason the will shows in probate is because a kid or a spouse or somebody knew about it and brought it to be probated. Because the courts don't have a database for wills. Like you don't put it in a database. There's not a record of it until it goes into probate. So generally, it's going to be a family member, somebody who's receiving under the will, something like that. They're the ones who are going to bring it. That's how the court knows there is one. Which is why it's important to communicate with whoever. Make sure someone has a copy of the will, someone you know who you'd have interactions with, knows you have a will, knows where it is, knows what to do. That's why generally whoever you've nominated as your personal representative, you should let them know and probably give them a copy of the will. So, yeah.
So then does a trust circumvent that problem?
Yeah, so a trust isn't registered either. It does circumvent having to go through probate, but it isn't registered. So it's private. Trust it's a benefit a lot of people like, which is a trust is private. A will won't be because it's going to go into the court, and I try not to submit inventories because I don't want it to be a public record of what someone owned. Because you can go to the court and you can request copies of any court document. There are some, like certain guardianship, certain cases that get redacted and sealed, but a probate's not one of those. So I had a client once, her husband had passed away and they did an inventory, and she had a lot of money, she had a lot of stuff. She was getting a little bit older in years, she was getting a little bit, there were some capacity issues, and she got scammed. And what we think happened is there were people just trolling, looking for wealthy older people that they thought might have low capacity, and they can tell because they look at the inventory. That's why I try not to submit. But sometimes you're just required to submit an inventory. But a trust is private. Well, thank you guys very much. I appreciate it. Thanks for having me.